wait any longer. So I'm going to just take a second to get the media up. And if anybody who's listening can just send me a message in chat so I can know that everybody can hear me before we start, so I can make sure that everybody's got both the visual and the hearing. So let me know if you can hear the audio, please. All right, so I think we have audio is good. Now give me a second to get the presentation going, and then we're going to jump into it. Can everybody see my screen now? All right, looks like we can, so I'm going to jump into it. I will do my best to keep an eye on the audio and visual, because once in a while there's a little bit of trouble, but hopefully we won't have that. So welcome to the Micklin Law Group's monthly webinar series. This month's webinar is What Women Need to Know, 10 Most Important Terms to Include in Your Settlement Agreement. Okay, let me give you a little background about what the seminar or the webinar is going to be like. It is scheduled for 60 minutes. Sometimes it's a little bit less, sometimes it's a little bit more, but I do my best to stay on track as much as I can so that the time you spend and dedicated to spend doesn't get utilized any more than you expected. But I will allow for any additional time if we need to cover the material or for questions. It is a one-way communication, so hopefully you can see and hear me, but I wouldn't be able to hear or see any of you. There should be a panel on the right side of your screen, which has a dashboard and some chat. That's where you can post questions. You'll see there's a pull down for questions and chat. I'd recommend you use the questions pull down for any questions you have. I will not answer questions during the presentation, but I will be taking them at the end for as long as it takes. But I recommend that you write the questions down as we go so that you don't forget to raise the issue, or at least forget how and what you wanted to ask me about. Let me give you a little background on me in case you haven't worked with me in the past. This is me. My name is Brad Micklin. I'm the managing member of the Micklin Law Group. I am a member of the New Jersey and Pennsylvania State Bar Associations. I'm licensed to appear in both state and federal courts. I began my career as a judicial law clerk to Judge Eugene Austin, who was the supervising judge of special civil litigation in Bergen County at the time that I clerked for him. From there, I went to Kessler and Associates. I did complex commercial litigation for a number of years until I opened my private practice, I think in 2001. The Micklin Law Group is concentrated in divorce, family law, and estate planning. My role is primarily to handle the high conflict and high asset litigation. We have 3 associates that also assist me both with those cases as well as the other cases that don't fit into that kind of complexity. Here are some awards that either I or my firm has received over the past few years. I put this just so that I think it's important if you are or may be working with me in the future to have some sense of who you're working with. I normally urge people to do research. Social media has become a great tool for people to really be able to research and learn who they're dealing with before you get involved with them. So I do this just to assist you. So enough about me. Let's take a look at what we're going to cover tonight. So the 10 different terms are broken down largely individually. The first one is going to cover annual exchanges of tax returns. Now, this is going to be what's considered post-judgment or after your case is settled, how to handle exchange of tax returns after handled. Later, I'll show you that we're going to talk about issues during and throughout the litigation. The second term that's going to be discussed is about wage execution. I'm going to tell you what the law says about it and how it is affected whether you have it or don't have it in your agreement or in your settlement. Next, we're going to talk about the different types of alimony. I'm going to discuss both the statutory alimony, or those that are prescribed by law, as well as a type that is created under what we call common law, or by usage over time. Then I'm going to talk about alimony modification. Again, I'll tell you what the law says and how the language of the law determines when it can be modified, but also give you terms and suggestions of how to protect yourself for and against modifications in the future. We'll discuss child support modification because that does differ significantly from alimony modification, so it's important to be aware of the differences. We'll then move into child support and other related provisions. That will deal primarily with different costs associated to child support, like unreimbursed medical, extracurricular activities, and the like. I'll move then into custody relocation. I'll explain a little bit about what the law says, and how you can make it easier if you anticipate having to relocate in your future. Another custody issue we'll discuss with number 8 are future plans or issues. Our role as family and divorce attorneys is to foresee what our clients cannot foresee. Having dealt with cases and clients for so many decades, we sometimes have a better sense of what problems and issues you may have better than the parents themselves. Number 9 is the second issue regarding tax returns. This is going to be the needs and problems that you can anticipate and how to eliminate some of them before and during litigation and settlement discussions. And then finally, we're going to talk about college contributions. It's a big issue in the media with that lawsuit recently where the young girl sued her parents, even though they weren't divorced, and I believe it was eventually settled. But it opened up an issue that I think is going to continue and progress through our legal system, so you want to address that now. Generally speaking, the reason for this topic and being this specific as a gender-specific topic, because next month I'm going to do a similar one for men and fathers. As you go through litigation, I discovered everybody tells you what the law is. You know, your lawyers will, the internet does, the judge will, settlement conferences, and then everybody says, now go out and settle your case. Nobody really explains that you're not bound by the law when it comes to settlement. And considering that over 90, I think it's 8% of cases do settle, realizing that you're not bound by, the four corners of the law gives you a lot of freedom to carve and craft agreements that are going to be helpful to you and your family. So let's now move into the first topic, which is annual exchange of tax returns. You want to include a provision in any settlement agreement, and this goes for settlement agreements, it goes for property settlement agreements and divorces, it can go to in-court settlements that you're putting on the record, consent orders. So while I speak of settlement agreements most commonly, I really mean any type of settlement at any point in time. So annual exchange of tax returns. Now, not necessarily annual. The term I usually recommend is exchange every 2 years. I think every year can be a little cumbersome for follow-ups, but of course you're not barred by asking for every year if you think there's going to be a lot of changes. So you want to have a provision that indicates the exchange of both tax returns and documents. Very important, because a lot of people, fathers, husbands, will provide things like their W-2 and say you should rely on this. Or they'll provide a year-to-date pay stub, even though they might be getting bonuses year-end. You want tax documents, but you also want the returns, because that's going to show you if there's other sources of income. They're going to tell you, obviously, if the income has changed, which is what you're really looking for significantly when it comes to support obligations. It will also do a couple of things. It will tell you if there's hidden assets, if you see interest income or capital gains that don't match up with the financial disclosures that you had in your case. Exchange of later tax returns will alert you to that fact that maybe something was omitted. It will also alert you to any new assets that have been acquired in the same ways: capital gains, interest income statements. That's a change of circumstances. It could also suggest a change of income. The assets themselves may be streams of income, which now needs to be considered into support obligations. And the reason this is important is tax returns bring you to a strange sort of catch-22 when it comes to support obligations. And that is, if you have reason to believe that the paying parent or spouse has an increase in income, which you want to use as a basis to change your support obligations, you have the burden of showing that. And the problem is, without tax returns, you don't ever have the ability to show that. sure, you can say things like he's driving a new car, he's bought a new house, he's having another child, but without proof, the court's going to say that's nice, but we can't modify support just because you believe something to be the case. So then you ask for tax returns, and they say, well, you can't have tax returns because they're confidential. So you're locked into this cycle where you can't prove what you need to prove because what you need to prove isn't allowed to be used to prove it. So you put in a term that says we exchange it every 2 years, and you eliminate that circumstance. Provision number 2 deals with support obligations, but when it comes to how it's paid, and it's by wage executions. Wage garnishment or wage attachment is an order from the court or government agency to withhold money from somebody's paycheck. Under the court rules in New Jersey, it is the preferred method of payment of all forms of support. So the court rules say that the courts should order a wage garnishment or execution in all cases where appropriate. The law even goes further to say that there's very few reasons to deny that. So even, for instance, consistent payments under the case law is not a reason to deny wage execution. So the court rules really favor it. The reason why you want to have support paid by wage execution is, one, for cost of living adjustments. The COLA adjustments are adjustments made to support obligations that account for inflation. And they are, and forgive me for not having this exact, it's either every 2 years they raise it 3% or every 3 years they raise it 2%. I'm not sure which one. I apologize for that. But it's around there. The difference isn't going to be significant. But the important thing to realize is, absent a wage execution, these cost of living adjustments will not automatically be provided for in your support obligation. And you cannot file in New Jersey asking for an adjustment to support for a cost of living. So if you have 6 years of support, you would say, well, I missed 2 cost of living adjustments, file a motion and ask for it. Court won't give it to you. Cost of living is not a reason to seek modification under the case law unless you have an agreement that says so. So wage execution will give you that automatic increase. And it's important to realize because a lot of people will have a long-term support obligation, like 10, 20 years of alimony. You'll have 18 to maybe 22 years of child support with college, that these cost of living adjustments will make a significant increase in the support levels that you receive over the years. Now, in the event that you can't get a wage execution by agreement, and in my experience, there are a great deal of men have a lot of resistance to wage garnishment. And I don't really know why, because it's so prevalent and common that it shouldn't matter. But I think a lot of people still believe it makes them look bad, like they don't pay their support. So a lot of people resist it. So inside of this provision of having a wage execution, you could consider to have payments, provisions that say if and when a wage execution will be granted. And you can also have it say that the person, the obligee, will also pay for legal fees and costs if you have to file a motion to enforce it. So you can have a provision, for instance, that says if 2 payments are missed consecutively, I have the right to get a wage execution. And if I have to file for the wage execution, the husband or father will have to pay all of my legal fees for having to do it. So either put in a provision to get a wage execution or put in a provision when you can get it. In the event you're not going to get a wage execution in your agreement, at least put in that you're entitled to cost of living adjustments every 2 or 3 years so that you won't need to do that. Quick side note, I didn't make this a term because it's a simple one, but it kind of goes through every agreement, and that is payment about legal fees, as I mentioned here. You want to have a provision in your settlement agreement that says the payment of all your legal fees in the event that you have to enforce it or there's a breach. The average settlement agreement or the common settlement agreement will say reasonable legal fees, which allows the court to deny some of them, if not most of them. And most courts will do that. They will chop it down to what they believe to be a reasonable level. If you have an agreement that says all legal fees, you point to the court and say, this was our agreement. The court has no discretion to award anything but all of the fees that you incurred. Next 2 provisions we're going to talk about deal with alimony. First, I'm going to talk to you about the types of alimony and then how to modify and when. So let's first look at types of alimony. Now, under the statutes in New Jersey, there are 5 types of alimony. There's open durational, which is what replaced permanent alimony. There's rehabilitative, which is supposed to help a lesser earning spouse re-enter a market or get back into the workforce. There's limited duration alimony, which is a fixed sum for a fixed time period. There's reimbursement alimony, which is the repayment for one spouse who contributed to the other spouse's acquisition of an asset during the marriage, like most commonly an advanced degree, one spouse put another spouse through med school, or possibly opening up a business. While one spouse was developing the business, the other one was working and paying all the bills. And last, there's pendente lite, which is temporary alimony or support that's ordered while a case is pending. Now, those are the statutory forms of alimony, but there's a sixth type that I discuss here, and that's term alimony. Term alimony is just like it sounds. It's for a simple set term of payment. It's a bargain for exchange. You agree to what it's going to be for and how much and how long. It's similar to limited duration alimony, except the difference is going to be term cannot be modified unless your agreement says so, because it's a specific dollar amount and a specific term. Limited duration, for instance, is for a term that can be modified not in its length but in its amount, which I'll go through a little bit in a second. But I don't want you to get wrapped up in why the other one's modified. What you want to take from this is that you can agree to a term alimony, and you can agree how and when, if at all, it's going to be modified. So you're not bound by the case law and the statutes for the other types of alimony. And because it's a bargain for exchange, as I mentioned here, a bargain for exchange, you can put in terms that maybe conflict or differ from the statutory language. But what's important also inside of this is you need to include a provision in your agreement that says what type of alimony you're agreeing to, whether it's open durational or term or LDA, limited duration. You need to, because each one is modified for different reasons. So it's important that you put in the term, but also put in why you chose that term. If it's going to be rehabilitative alimony, for instance, you want to put in what you're seeking to rehabilitate or the reasons why you need it to be rehabilitated, because, well, I'll go through it in a second in the next term, but modifications of each one is going to be different. Once you have the term in your settlement agreement, once you have named the type of alimony that you elected, you also want to keep notes as to why this was chosen, and you want to keep your case information statements, which are usually documents that will be exchanged when selecting an alimony type, so that later, if there are issues of modification, the agreement, your notes, and your case information statement will all support that. Looking at modification, first I'll talk about term, because that's really the reason why I emphasize term as the statute is because it's something that most people don't consider as being an option for alimony. Most of the time, it is considered limited duration alimony when your agreement just says alimony for 5 years. My belief is that's not the case. My belief is when you say 5 years, it's term. And that way you know whether or not it's modifiable by your agreement. It'll tell you whether or not there are changes of circumstances that allow for it. And you may even trigger a time to evaluate it. But with term only, because the other forms of alimony all have statutory language that determines when it ends. Typically, all alimony will end at death, marriage, or cohabitation. Death, remarriage, or cohabitation. But it can also be for any other reason that the parties agree to. And this is what I want to stress throughout most of this webinar, is that you're not bound by what the law says or what the judges say, as long as you know to put it in. So what's important when it comes to modification is to know the type of alimony, because each one modifies for different reasons, so provision number 3 was to put in the type of it, but even number 4, you can put in how and when it modifies, even if it differs from what the statute says. Like, for instance, open durational is the new form of permanent. It will generally or could terminate at retirement. Rehabilitative will terminate when the conditions upon which the alimony was sought to alleviate have been achieved. It will terminate. Limited duration will terminate at the time when it's supposed to end. Pendente lite terminates when the case terminates. Reimbursement is usually a fixed sum and a fixed money, so there's really no termination because it can't be modified or extended. And then term again when it's set to expire. So you may be agreeing to a limited durational or term or even open durational, but you want to specify in your agreement whether or not it can terminate, or I'm sorry, whether or not it can be modified. Most agreements will also contain something called an anti-lepus clause. Lepus is the case, Lepus versus Lepus is the leading case in New Jersey that discusses how and when a change of circumstances allows for modification of support. So most agreements will have an anti-lepus, meaning you cannot modify your support. Most people don't read it that carefully and realize that that's what it's saying. And even when the agreements are brought into court and they have those provisions, a lot of judges ignore it and they allow the modification. So you want your agreement to indicate the type of alimony and if and when it's going to be or can be modified, under what circumstances and when. Next is going to be issues for support, but regarding child support modifications and other provisions. So number 5, excuse me, is going to be modifications to child support. So child support is a very unique support aspect because while the courts take a very strong position to support children, it's the public policy of our state, it generally also says that a support modification for child support only occurs with a substantial and material change of circumstances that are in the child's best interest. Both of those phrases are very nice sounding, but they're very hard to interpret with specifics, and it's hard to determine if the court's going to feel that you've met that burden or that change of circumstance. So to start, you want to include a term that tells when modification is going to be appropriate, whether it be a time frame, a certain age of the child, a certain activity or life change, like change of school or entering school. You can also, or should also, determine and define what is a material and substantial change of circumstances, because that's the catchphrase that courts will look to when deciding it. Change of circumstances can either be school events, they can be medical events, simple passage of time. It can be anything. And it's important to define it because things like passage of time is not considered a material change of circumstances for the court. So if you want to review child support in 5 years because your child's going into kindergarten, although you may have a change of circumstance because of the school, but in 4 years you won't have one. So you'd have to wait until the 5th year before you can argue a change of circumstances, unless you define it in your settlement. You can and also should address when it ends. Typically, child support, well, first let me say, in New Jersey, child support technically does not ever end until the court ends it. The standard is once the child moves beyond the sphere of parental influence, which means once the child no longer needs financial support, the court will terminate child support. And that can be indefinite. Certain children that have special needs may be recipients of child support for their lifetime. But that being aside, child support is presumed to terminate at 18 unless the child is going into college. But it becomes the paying parent's obligation generally to file a motion to terminate it. But I think that people should consider terms in their agreement as to if and when it will end, especially if you have or anticipate there may be special needs. And special needs don't mean physical or mental limitations. They could mean educational opportunities and special activities. So generally, it's going to end at 18, marriage, separate residence, death, armed forces, and full-time employment. But this doesn't mean that that's the only time it can end, and it doesn't mean it has to end at these. Another thing to look at is a lot of children take a hiatus between high school and college because they're not sure where they're going to go. And without a term about how child support ends and when it ends, that could be a reason to terminate it, where you might just have a year before the child's returning back to school, and then once the child's emancipated, you don't get child support. So it's important to address child support termination as early as you possibly can and not wait for the conditions to actually come to fruition. Now let's look at other related provisions about child support. We have extracurricular, extended parenting time, deviation, education, and unreimbursed medical, to name a few. The reason I do this, I think these provisions are important, is I have a lot of issues with the child support guidelines as they exist now. As most of you may or should know, child support's done essentially by a calculation of combined incomes. And while they adjust it every several years, it's still not necessarily reflective of the costs of raising children today. I think the guidelines were created in like the 70s. And lifestyle for children was very different in the 70s. Children played in the streets and they went out trick-or-treating by themselves. Now you have play dates and hockey tournaments. So the costs of raising a child, at least in North Jersey, is a lot different than when the guidelines were created. And secondly, the guidelines are universal throughout the state. So while somebody in South Jersey that has probably a much lower cost of living will get the same amount of child support based on income as a person living in, Bergen County or right outside of New York. So I think there's a lot of reasons the guidelines need to be reevaluated. But going to these issues here, many of them are addressed in the child support guidelines negatively, and a lot of parents aren't, or mothers, I should say, aren't really aware of that. So extracurricular activities are considered to be included in child support. So if you get a child support award, you will not get contribution for extracurricular activities. So I always recommend that you put in a provision that provides that the other parent will pay either a percentage or based on incomes. The good thing about this is most people don't know that extracurricular is considered part of child support. So many will agree to pay it because they're not aware of it. But you want to, because it can be exceptionally a significant amount of money over the life of any child. You can also put in provisions that the other parents should not enroll the child in extracurricular activities without notifying you, or that you're not responsible for it if the other parent enrolls them without your knowledge. It's an important term you should consider when it comes to extracurricular activities. That is often a problem between parents. Excuse me. Extended parenting time. Now, this is addressed, but it's important to realize it because it becomes an issue often. And that is, there's no suspension of child support with extended parenting time, visitation or parenting time. Meaning, if the other parent has a week for Christmas or they have the month of August, child support still continues. They're obligated to it at any point in time unless you have an agreement that says otherwise. Now, you could put in a term that says it does not terminate at extended parenting time, and that is just so that the other side is on notice of that. I've had issues where one person thinks it, so they stop paying it, which is wrong, but it couldn't hurt to put that provision in so everybody's on notice that they must continue support obligations. Deviations. You can deviate from the child support guidelines if it's in the best interest of the child. The guidelines are presumed to be correct and presumed to be in the child's best interest, but the court does allow deviations, up or down. If you're going to deviate, it is very important to put into your agreement or on the court record or in a note to the other person something, explanations for why the deviation was utilized. There is a recent decision, maybe a year or so ago, that says when the court looks at applications in the future concerning child support where there was an earlier deviation, the court needs to determine whether or not that deviation is or should be intended to carry forward through the life of the child support order. So let's say you're getting divorced and you agree to child support and you increase child support because the marital residence hasn't been sold and there's, you want to have more income into the family home until it's sold. Well, 5 years later, the house is sold and you're reviewing child support. They know you deviated from the guidelines, but there's nothing that tells you why. So if the house is gone, then there's reason to change child support. You don't want to have yourself exposed to an argument where you're getting more child support that you've come to rely on, and then have somebody file a motion later saying that you've paid above the guidelines and the deviation should be reversed going forward. You want a term that says why you deviated and whether or not the deviation is intended to be utilized in future modifications or with future support issues. Education. And we'll talk about education here and we'll talk about it with college because it is going to be different. But education is usually not, I keep saying not because you don't get child support, so I always think of it negatively. But it is considered included in child support, meaning if you enroll your child in a private school, you're not going to get contribution unless the other parent agreed to it. So if you are anticipating that you may have a desire to send your child to private school, religious school, whatever type it may be, you want to put in a provision about how it's going to be paid, including the tuition, the tests, the fees, and etc. This can be for private school. It can be for religious training, which is separate and apart from their educational programs. And again, we'll talk about it later with college issues also. Last is unreimbursed medical expenses. And here's another place where parents, usually mothers, get caught up in what the law says, and that is the guidelines provide that the first $250 of unreimbursed medical per year per child gets paid by the custodial parent. So if you're the one that has a child, that means wellness visits, prescriptions, vitamins. The average child is not going to incur that each year. And if you have 3 children, that's a significant money that has to be provided for. You are able to, and you should have a provision that says the other parent's going to contribute to a certain amount of unreimbursed medical. You can either do it by a percentage, you can do it by a fixed amount, but you do not need to be bound by the guidelines which say that you have to pay it. And if you have a child with special needs or allergies, when it comes to special foods, things like that need to be addressed, because that also is not going to be covered by child support, and you're not going to get anything separate or above for that. Now let's move past support obligations and let's talk a little bit about some custody issues. The most common issue is often relocation, and then we're going to look at issues in their future that should be addressed as early as you possibly can. So first, let's look at relocation. Now, the standard for relocation, in my opinion, is not very challenging if you're not equally sharing physical custody. I'm not going to get too deep into that, but if you have the traditional type of parenting schedule where parent of primary residence, which for the purpose of today we're going to say mom, and then dad has like every other weekend and holidays and things like that. The relocation standard is not very difficult if you have a good faith reason for the move, and it's not going to harm either the child or the child's relationship to his or her father. The court will give you permission to relocate. But it's not because that the standard is easy that I'm addressing this. It's because even though it's easy, the procedure to establish it is very difficult and time consuming. So if you believe that you're going to have a change of circumstances in your future that may cause you to want to relocate, you want to address it with a provision in your settlement agreement. Like I have one here as just an example, like relocations within 20 miles or more are material and substantial. You can determine whether or not that is or is not. You can put that the intention of the plan is to have relocation in your future. You can put whether or not a certain distance is or is not permitted. You also want to, inside of the relocation and custody issues, you want to put in agreement the intention of your current custody parenting time plan. Just like I said about alimony, when you want to put what the intention was, you want to have information on the record or in your agreement that speaks to why you have a certain custody agreement. Like if you have the traditional one, you want to indicate this to the extent you can get it in your agreement, that the parties believe that this is in the best interest of the child, or that the mother is has been the primary caregiver for the child's primary life to date. And that's important because there often are future challenges, and you want to be able to show that the intention behind the parenting that the parents elected as being the best interest of their child at the time still exists. So if you've been a primary caregiver and that's in your agreement, you currently have been, then any challenge to custody is going to be weak and a lot easier for you to defend. And then lastly, you want to have, if there's specific intentions for relocation, you want to indicate that. Even if you're not certain, but if you have family that's out of state, you want to put that the parties may relocate, or that the father understands there may be relocation. And while that may sound like it's going to be difficult to obtain them to agree to it, you're right, it will be. But bring the issue out now when you're settling terms, so that's out on the table, so that you know what to do. And even later, if you don't even have the term, you can at least have your notes from the discussion. But at least it's not going to be a surprise, and you're not going to find yourself battling in court when it comes up. And even real quick on this topic too, even though it's not relocation, but if you're going to be traveling, you probably want to include a term that allows for traveling, whether it's interstate or inter countries, intercontinental, because that can be a challenge too. If the non-custodial parent, the father, wants to be a pain in the ass, he can complicate travel. He can refuse to sign passports. You have to file motions. If you think you're going to be traveling in your future to see family, or because there's parts of the world you want your child to see, I'd put that in your agreement too. That's just a side note. Side note, we won't count that as number 11. So let's look at some future custody issues. Again, like we touched on with child support, there's education, there's extracurricular, there's religion, and there's going to be modifications. So first, education. You want to put in a term or terms that talk about what your intentions are for school, private and public, and after-school programs. This is going to be important in many aspects of your co-parenting. It's going to affect the child support. It's going to affect the lifestyle, but you're also going to have a lot of things that come up around education issues and extracurricular and religion too. You're primarily going to have things like where you're going to have to live. You may have to relocate because you want different educational opportunities. You may have to transport the child to and from, which may increase your costs. It may create different daycare and pre-care, aftercare responsibilities. So if you can put in terms that indicate what your future plans or intentions will be with education, arguing that the other points need to be addressed, like increased costs, fall right in line with that. Extracurricular activities. You want to put what the intention for extracurricular and how to split them. You want to have provisions to discuss the expenses before so that you don't get kind of sidebarred into not getting them. I put language here. You want to have a provision that says that consent will not be unreasonably withheld. And that means that you put the parent or father on notice, and if they have a good reason, a good faith reason, they have to consent to it. And you want to spell this out in your agreements because you don't want to be fighting over whether or not you can take the karate class or whether or not your daughter goes into ballet. Put the provisions into the agreement. If you have some idea of special talents or hobbies or interests that the child has, put in that you anticipate in the future that they will engage in these activities, or that you had other children while you were married, for instance, that engaged in these activities, and you anticipate that that lifestyle is the one you're going to want to provide to your younger children. It's just going to eliminate future problems, court appearances, and arguments. Next, religion, very large, very big issue, especially if the two parents disagree, or have different religions. There's often change of parental religions when new relationships are formed. So, husband and wife divorce, mom remarries and may convert or raise their children in different religions. Now, the law will generally say, as I put here, that the parent of primary residence will usually be the one that chooses the religion. And that's still good to consider, but the problem and the purpose of this is to teach how to avoid having these issues. So even if you share the same religion, you may want to indicate somehow that the parent, in your agreement, that the parent of primary residence is going to be responsible, let's say, for transportation of the children to church or to synagogue. That type of a term will implicitly state that the intention was to raise the child in this religion. You could try to get terms that say, the parent of primary residence chooses the religion, and should that change in the future, she's able to change that without returning to court. Again, difficult provisions to get agreement to, but it's better to put it out there in the beginning and see whether or not you can get it, maybe even bargain for something so that you have it, because you're going to be saving yourself problems in your future. Modification, as we kind of touched on before, you want to set triggers to evaluate when you should modify custody. Not the support aspects, but actually modifications of the custody. What you want to try to do here is indicate what's going to be best for the child. But really what you're doing is trying to eliminate future attempts to modify custody. Quite honestly, I've seen a lot of people who fight and file for custody as a retaliatory type of abuse. Most do it in good faith, but there are some who abuse it as a way of control. So you want to indicate whether or not there is a time or a circumstance by which custody should be evaluated. This goes back to what I was saying before about putting in the intention of what your agreement was. And also the legal fees you may want to build in to your custody provisions. If there's an unsuccessful custody application, the person who loses it pays all legal fees. So again, even if you do find yourself unable to prevent it, at least you have an agreement that protects you and gives you some kind of compensation for the costs that you may incur trying just to defend it, whether it's bogus or not. Tax returns, This is just some advice about how to handle tax returns during your litigation. See, there's a lot of issues that come up especially during a divorce, and that's the liability. If you have different tax returns being filed separately, or if you have maybe one spouse that was self-employed, you want to know and have an agreement how to handle the liability for any tax deficiencies that may have occurred. If there are any tax deficiencies, you want to get a statement that says whether or not there are. And you may, in that kind of case where there's a possible tax deficiency, or you have like a separate filings or a self-employed individual, your provisions should indicate what would happen if there is a deficiency discovered later. You can put in, like I have here, whether or not the other person, you being this person, whether or not they're responsible for the deficiencies of underreporting, or whether or not you're responsible for any deficiencies. You could indicate what involvement you had or didn't have in the utilization of the business and the funds, how you handled money, whether you had any access to it or any knowledge of it, or whether they controlled it. These will all be important terms, like whether you had access to it or had knowledge or had any control of it. One, if there's a deficiency and there's a legal problem in a divorce case, but also there's a lot of IRS remedies that I won't go deep into. Essentially, there are innocent spouse relief, separation of liability, and equitable relief. They all have different reasons that you're entitled to relief, but if you have an agreement that indicates, and you might want to build into this term, the protections under those three remedies, so that the language in your agreement mirrors the language you'd have to use to indicate that you were sort of innocent of any knowledge or contact with the money. If it's in your agreement, it's a lot more persuasive to the IRS. It'll be a lot more persuasive to a family court if there's issues later. All right, let's turn to college contribution. Very big issue. Like I said, that recent case law has raised the issue. And what I think is going to happen eventually with college is they're going to have to address the issue that was raised by that girl against her parents. Because right now, the way the law stands is that divorced parents can have the court order one of them to pay for their children to go to college. Married parents cannot. And that's an unequal protection of the law that will eventually have to be resolved. So here are the things you want to decide when it comes to college contribution. You want to have terms that indicate what level of involvement, if any, the other parent needs to have, and what that party's responsibility for that involvement is. You want to discuss how the decision is going to be made, how you're going to determine whether or not there's an ability to be paid. But more importantly, try to put in language that speaks to that. I put it here, no absolution for parent if there's no space for meaningful input. Meaning, even if the other parent's not involved, you want a term that says they have to pay anyway. Now, that's going to be a hard one to craft, and it's going to be a hard one to enforce. But it's very important because most people, when they're sending their child to college, aren't thinking about the future court battle they're going to have. So they pick up the phone and they call dad and they say, we're going to Rutgers, do you want to come? And he says, no. Well, then later you can't prove that you called dad, that you involved dad, and you don't want to be sending confirmation emails to the father of your child while you're in the middle of choosing colleges. So you want to, and if you believe that you're going to have a parent that may be less involved or may be the kind that tries to skate around the responsibility by pretending he wasn't involved, put in a level that indicates it's their involvement, or his requirement, to be involved, that he is going to be aware of the age at which they're going to be seeking school, and he has the affirmative obligation to contribute or to be involved, that you will take the best efforts to involve him, but that it's his burden. Next thing you want to address with college contribution is the type or level of school. You can first say that, in an agreement that it is your intention for your child to go to college or not. I generally don't recommend anything but that there is the intention your child go. You can put in a provision of whether or not the child has to perform to a certain level or not. You may want to try to make it as easy as possible, especially if you have a child that may have special needs. You may want to mention that the special needs will be considered when deciding. But the important thing about level of school is there's something called the Rutgers rule. And a lot of people fight about this, and that is the non-custodial parent would usually take a position that he should only have to pay to the amount that would be required if the child went to a local school, like a Rutgers school, regardless of where the child's going. And that's often very persuasive, and that leaves the burden on the other parent and the child. It may actually frustrate, if not eliminate, the ability to go to college. So you may want to indicate in your agreement that you are not going to be bound by the Rutgers rule, that you're going to be choosing the level school commensurate with the child's ability and grades. And then lastly, contribution. You want to determine, or you want to put in a provision that indicates how much and when the person is going to be. So you want to define the percentages, or at least how you're going to determine it, because sometimes you don't want to necessarily define on percentages if college is far way off. You want to put how it's going to be determined. So it's because usually we use language right now that says, based on the circumstances as they exist at the time. And that's a meaningless phrase that finds its way into most common settlement agreements now. But you want to put, the parties are going to agree to submit 3 years tax returns to an arbitrator 1 year before the child attends school. It can be done. It will facilitate determining child support. It will eliminate litigation. But if it's not in your agreement, it's not going to happen that way. You also want to define what college expenses should be. Most people say tuition, room, board, books. But there are lab fees, there are registration, there are computers. There's going to be furniture if the child's going to be living away, food, meal plans, clothing. You can put in anything that you want to define college, but if it's not in there, you're going to be limited pretty much to tuition, room and board, and books. And then lastly, there usually will be a provision that indicates a child is required to get financial aid, grants, loans, and scholarships. I usually recommend putting that in there. That protects both parents, because a lot of parents, with the cost of education these days, simply don't have it. The child must seek that. Moving along, that was 10. So before I move into questions, I just want to give a couple of closing points that I want everybody to really take from this webinar. And that is, first, you're not barred or limited to what the law says. That's what everybody's going to, they're not going to tell you that you're limited, but when you ask people, or you go to your lawyer, you go to court, you're going to be told what the law is. You don't need to operate inside of that framework. You really should try to operate outside of that and make it really specific to you and your family's future needs. Second thing to take out of this is you should include every single thing you can into your agreement and be very specific. You want to put in why things were agreed to, why things were removed, what the discussions were about. Even if it's not in your agreement, at least take notes and keep your notes somewhere so you can later support the reasons for these things. You may want to include, now this kind of goes to all the 10 provisions, but really the settlements and agreement, you may want to include terms that say that these issues, when disputed, will go to arbitration or mediation or a collaborative law process, because challenging settlement agreements and modifying support is a very complicated, time-consuming, expensive undertaking. Your agreement can and should indicate if there's going to be alternate methods of resolution utilized. You also want to put in, as I mentioned throughout this, provision for payment of all legal fees if there's an unsuccessful application in any form. That will eliminate a lot of bogus challenges. It will also eliminate a lot of the problems that are created. Those are the important points to take from here. What I want you not to take from here is that if you do not have these terms in your agreement, that's not a bad thing. It's not like you're going to have significant problems because of it. It's not like you had a bad lawyer who didn't tell you the right things. Every agreement is going to be different, and every circumstances are different, and it's impossible to foresee future circumstances entirely. But these terms are just intended to prevent the most common problems that you're going to have, and they're advisable, but it's not the end all if you don't have it. Another thing to remember is that the other person will probably not agree to most of these. You're going to get a lot of opposition. You'll need to know or be prepared to offer some things in return if these are important provisions. And even if they all are accepted and all aren't in your agreement, doesn't mean you're going to eliminate all of your future issues. There's still going to be problems. There's still going to be ambiguities. This is just an attempt to help you eliminate some of them, or at least anticipate what may be some of them in your future. Real quick, here's some contact information. Most of you probably have it through the email that I sent at the registration. but if you want to jot it down real quick, I'm going to also take, like I said in the beginning, time to answer some questions. So if you want to go ahead and pose any questions you have, I'll stay here as long as we need to complete this for you. I'm not seeing any questions. Like I said, I'm more than happy to take as much time. I'll wait another few moments to see if anybody has any before we close out. Still seeing none. A little unusual. Makes me worried that maybe people can't hear me, but I haven't seen any messages that they can. So again, I'll give another moment or two. I'm going to check my panel. Maybe I'm looking in. Maybe there's other comments somewhere else. All right, going once, two. All right, with that, I thank you for joining us this evening. I hope it helped you in some way. If you have any issues or questions that I did not address, you can certainly give me an email to brad@micklinlawgroup.com. Otherwise, I wish you a good night. Hope to hear and sort of see you next month at our next webinar. Good night.